It is a matter of deep satisfaction to me that you have given me an opportunity to meet so many lawyers and judges on this occasion. It is not often that I get such a chance. There was a time when, while practicing in the courts, I used to meet judges and lawyers quite often, but if I were to revisit those old places now, I am afraid I may find only a few familiar faces and the rest quite new to me. The pleasure is therefore all the greater because you have enabled me to meet so many of you today. You have rightly said that under the present Constitution of India, the courts of justice play a vital role. In the very nature of things, a federal constitution requires judges to decide disputes not only between the individual and between an individual and the state, but also between a sovereign legislature on the one side and maybe a humble citizen on the other. I am glad that during the short period of the working of our constitution, our high courts have been discharging their duties to the satisfaction of all and also helping in raising the moral standard of the people. I hope and trust that in future the value of the work of men in the legal profession, men of the judiciary, and all men engaged in judicial work will be recognized even more than it is today. It is a matter of concern to all of us that justice should remain suspended in the case of many litigants for years, not because of lack of diligence on the part of the judges, but because of the very heavy pressure of work. I was painfully surprised to learn that even in this court you have large accumulation of which has gone on mounting during the last 50 years or so. I do hope that something will be done soon, not only to clear arrears, but also to see that in future there is no accumulation of work for other people to attend to. Our Home Minister has been very anxious and he has been telling me every now and then that in many cases there is a delay in the disposal of cases because the complicated procedure of law makes it difficult for courts to dispose of their cases as quickly as they wish to do. He has been working at a solution of this problem with great diligence, and I am sure within a very short time a new law will be introduced to reduce the reasons for procedural delays. But as I said earlier, this is not the only aspect of the judge's work which we have to take into consideration. We have now a different set of circumstances in which the judges and all those who are concerned with the courts have to act. It seems to me that in a welfare state, the very nature of litigation will change, and all of you who have been practicing from a long time will be able to testify to the fact that the nature of litigation in this state is undergoing a change on account of the abolition of what is called the zamindari system. If you turn over the pages of the law reports, you will find any number of cases dealing with the rights of zamindars and landlords. It seems to me now that the zamindari has been abolished. The whole system of litigation relating to zamindari rights and their inheritance and things of that sort will disappear. But at the same time, we are adding to the work of the high courts in another direction. You must have noticed that the petitions for writs under the Constitution now occupy a pretty important place in our courts for quite some time, till the law is adequately understood by the ordinary people and it is authoritatively interpreted by the courts. Such petitions and writs would continue to occupy an important place in our judicial system. In course of time, however, as the law becomes more and more definitely settled by authoritative decisions of courts, such cases are sure to diminish. Another kind of litigation may crop up when our industries grow and when the volume of our trade and commerce increases. We shall then have a large volume of what may be called commercial cases or cases dealing with labor or disputes between capital and labor. Therefore, I would say that while you are in this profession, please bear in mind that after all, it is a noble profession in which the payment of fees is not so important as is sometimes imagined. I believe in England, even today, a barrister cannot sue a client who defaults or refuses to pay him his fees. It is so because the lawyers are supposed to be officers of the court, required to assist the judges in deciding cases. The money part of cases is only a secondary thing. In course of time, however, this latter aspect grew in importance. We would do well to go back to those early times and prepare ourselves for selfless work, because even according to our own traditions, the Pandit who assisted the king in dispensing justice was not paid any fees by the party, although he might have been paid by the king. Whatever that might be, I have no doubt that under our present constitution, the importance of the legal profession and certainly of the judges will grow. You are rightly proud of the traditions of your court. If I may say so, not only your court, but all our high courts in India have maintained a high standard of justice, integrity and honesty, and of fair play and fearlessness in dispensing justice. It is for this reason that we can look back today with a great sense of pride and satisfaction.